attention to everything that I said to you in my letter. But I would just like to publicly state that I'll apologize to the people of the state of New Mexico, to my family and my friends. And I'm truly sorry. I would just ask, I'm sorry. I would just ask this court for forgiveness of me and see when you close your sentence. Thank you.
Give me a minute, if you want to have a seat for a second, that's fine. Have a seat for a second, let me update my notes before we continue. As I begin, I want to make a couple of comments to begin with. Judges and courts don't get to speak about cases unless they do it from here, from the bench. We don't return phone calls to the public or the press. We don't engage in conversation with friends or colleagues about ongoing cases. It's inappropriate. The only time a judge gets to speak and address the issues that are before the court is when the court is acting in its official capacity and making decisions, and in this case, rendering a sentence. Sentencing is not an open-ended proposition. It is limited by statute. Every crime created by the legislature, or county commission, or city council all sets out the penalties, or at least the maximum extent of the penalties. The sentencing authority of the court is also controlled by statute, and it sets the parameters for what's available when the court suspends any portion of a sentence. During her comments a moment ago, Ms. Johnson referred to the federal case Kuhn. Kuhn gives direction to every judge to look at every case as unique and to look at the accused and the effects of the crime, not in general or as a group, but unique to that individual case and to the individual crime. In this particular case, the court takes a number of things into consideration in fashioning a sentence that I believe approaches, or at least attempts, to administer justice in this particular case. First, the court looks at Ms. Duran's acceptance of responsibility. The original 65-page, 65-count criminal information was extensive and covered many crimes over a long, extended period of time. In addition, it looks at the actual plea agreement that was entered into between the parties and the parameters, and listens to the suggestion of the state. The state is in a unique position. By that I mean the prosecution in the form of the Attorney General's office is in a unique position to know the detail of the case. A judge, I do not know all of the issues. I do not know the nature and extent of the evidence that would have been presented at trial. The state, in its negotiations with the defense, has weighed those factors and has come forth and made a recommendation to the court. The court also looks at the defendant personally, looks at the history of the individual, looks at the circumstances under which the crimes were committed, and tries to find an understanding, if not an explanation, for why these things occurred. The court also looks beyond that to the effect of the crime and the impact that this had not only on the individuals but also on the community as a whole. I'm going to introduce some of you to a term that you may have never heard before, and that term is restorative justice. The concept of restorative justice has been evolving over the last 40 years. It is a framework to try and understand and to try and sentence in a way that addresses particularized goals in every case. It goes beyond simple punishment or simple mercy. It's an attempt to articulate detailed goals and how the sentence and the components of the sentence addresses those goals. The components of any criminal sentence are very straightforward and the same. I combine them into really three categories. One is restitution, and we've talked about restitution this morning. The second is rehabilitation, and the third is punishment. And I will address all three of these as I go through the sentence in this particular case. I'm going to address the case in two parts. I'm going to address counts 1 through 4 as a group, and then 5 through 6 separately because they're of a different nature. Many citizens come before this court with addictions, whether it's alcohol or drugs or gambling. In reviewing the evaluations and reports and getting some of the history of your particular addiction, Ms. Diane, it is very similar to what I see day in and day out. The control of an addiction, inability to address an addiction, destroys an individual's life. It also destroys the lives of the people around them. There are many people that are addicts that are what I call functioning addicts. They get up every morning, they go to work, they do their day's work, they come home, and either drink themselves into a stupor, or shoot up, or go to the casino. I'm a bit concerned about your statements, and even when I read your letter was concerned, because it sounded very familiar. Many of your statements follow a pattern of rationalization and excuse that I hear from many addicts. It is very similar. The reason I think that occurs is because people try to make sense of their behavior. They're trying to understand it and trying to put it into context. And they minimize it. They minimize the effect it has on them personally, and they minimize the effect it has on everyone else around them. I'm going to deal with the easiest of the three components first, and that is restitution. The court orders that $13,866.80 be paid in restitution. $1,050 to the identified individuals whose campaign contributions were diverted. $9, that would include MAC Energy, the 2,300 amount as well, and all of that money will be returned to those individuals. You will write a letter of apology to each of those individuals, and you will deliver it in person. The balance of $10,516.80, which was converted from campaign funds to your personal use, and cannot be easily traced back to any individual contribution, will be divided pro rata between your contributors over the relevant time period. And you will write a letter of apology to each of them. The next topic I would like to go into and discuss and describe the court's order is rehabilitation. Under the framework of restorative justice, rehabilitation is broader than simply helping an individual try and address the problems that led to their crime. Rehabilitation is also a way of restoring at least some modicum of balance between the individual and society as a whole. The first requirement of rehabilitation as part of the portion of this court suspended sentence is you will continue counseling and therapy with Dr. Aguilio. I know it is very difficult for people with addictions to maintain their sobriety if it's a chemical addiction, or in your case, to refrain from engaging in gambling. This court has dozens, if not hundreds, of people on probation, conditions of release, on electronic monitoring. The court orders as part of the suspended sentence that you will be on GPS electronic monitoring for the next 3 years. Exclusion zones will be created around every casino, racetrack, and other gambling establishment in the state of New Mexico. And you are prohibited under this sentence from entering any of them unless approved for a particular purpose by your probation officer. The next component of your rehabilitation is to write a letter to the people of New Mexico and apologize for your conduct. You will cause that letter to be published in no fewer than 6 publications of general circulation throughout the state, and those will be divided by region so that the entire state has coverage. Let me back up for a second and say one other thing about the electronic monitoring. If you have had no violations of any of the conditions of your probation for a period of 2 years, you may, by motion, request that the 3rd year of your GPS monitoring be lifted. The next component of rehabilitation is community service. The court orders that over the next 5 years, you perform 2,000 hours of community service. That's 400 hours a year, approximately 30 hours a month. You will donate your time and labor to approved charities within whatever community you are living. You will not be compensated for it. You are not allowed to raise funds or control any money for any of those organizations. One more component of rehabilitation, but we'll come back to that in just a moment. I'd like to discuss the 6 counts for which you have pled guilty to individually. The first 4 counts of the plea are fairly common. Embezzlement and money laundering. These are economic crimes. There were specific individuals that were harmed as a result of those crimes. Because of the amounts involved, 2 of them are felonies. counts 3 and 4. For those 4 counts, the court imposes the following sentence. As to count 1, the court imposes a sentence of 364 days and a $1,000 fine. As to count 2, the court imposes a sentence of 364 days and a $1,000 fine. As to count 3, the court imposes a sentence of 1 year and 6 months and a $5,000 fine. And as to count 4, the court imposes a sentence of 3 years and a $5,000 fine. The court suspends an initial sentencing only the jail or prison time associated with each of these 4 counts. The next 2 charges are very different than the first 4. They are not charges that the average citizen faces because the requirements that create them are not common to the average citizen. They are unique charges related to candidates for public office. The reporting statutes require candidates to disclose to the public to file the source of the funds that the campaign receives and how the candidate spends the money. In these reporting statutes, a right is created for the public. It's an important right. This right is one of transparency. The public, in exercising its civic responsibility in electing public officials, has the right to know where the money comes from. There is also a limitation on how candidates can spend money that is donated for a political campaign. There's actually a list. Personal expenses and gambling debts are not on that list. The harm associated with these 2 crimes is also public in nature. It affects public confidence in their elected officials individually and also in the offices that they hold. Ms. Duran, you wouldn't be here if you had been probably a candidate for City Hall for some county position. The reason you were here is because you were entrusted by the people of the state of New Mexico to enforce the campaign laws. And that is a portion of the crime that you have committed. Again, going back to my discussion earlier of restorative justice, rehabilitation under that concept or that paradigm is broader. It attempts to try and address the damage that has been done. And you were in a unique position to address that. We've had a number of public officials in the last several years who have been convicted or pled guilty to criminal the private funds donated to your campaign that you converted to your own use. Although you stole the money from these individuals, the damage it created is much broader. The previous elected officials I described a moment ago have all been sentenced. They've all done at least some jail time. but they've also slipped back into anonymity, except for a case like this where another public official is charged with something. We don't hear about them. For many other types of crime, we have programs addressed to try and restore the balance between the community and the individual. For DWI charges, we have victim impact groups. For domestic violence cases, we have domestic violence classes, batterer intervention programs. But for this type of crime, there is nothing in the law of its equivalent. Today, we're going to remedy that defect. As a condition of your rehabilitation, you were required over the course of the next 3 years to give at least 4 public appearances per month. You will speak to schools. You will speak to civic groups. In these presentations, you will discuss your life, the service you have provided to the state, the crimes you have committed, the effect that those crimes have had on you personally, and the broader effect that they have had on the community as a whole. At least 1/4 of these appearances will be in an educational setting. Junior highs, high schools, colleges. You will speak to students about government. You will speak to the students about how your life's pursuit of a career in government was cut short. This requirement, I believe, does 2 things. One, I believe it to be part of your rehabilitation. 2, I believe it's a start in restoring the faith that the public has in the office of the Secretary of State and in the other candidates who seek public office. I'm now going to address counts 5 and 6. For count 5, the court imposes a sentence of 364 days and a $1,000 fine. For count 6, the court imposes a sentence of 364 days and a $1,000 fine. As to counts 1 through 4, the court suspends all of the underlying time, which is a total of 6.5 years less 1 day. As to counts 5 and 6, the court suspends 334 days. The court imposes a fine totaling $14,000, 30 days of incarceration, and 5 years of supervised probation under the terms that I have described. Is there need for clarification of the court's judgment and sentence? Ms. Moran, you have prepared the order, so I'll allow you to go first.
For a moment, Your Honor.
Yes.
Your Honor, just 2 points of clarification. One, we just wanted to clarify that all of the sentences are going to be served consecutively.
Counts 1 through 4 run consecutive to each other. Counts 5 and 6 run, let me start over and say that again. Counts 1 through 4 run consecutive to each other for a total of 6.5 years less 1 day.
Thank you, Your Honor.
Counts 5 and 6 run concurrent to each other, but consecutive to counts 1 through 4. So the total sentence is 7.5 years, with all but 30 days suspended.
Thank you, Your Honor. Can I just inquire as to the court's order as far as incarceration imposing 30 days? Is the defendant to be remanded today, or is this the court's intention?
Speak to Ms. Johnson about that in just a second.
Thank you.
Please have a seat. Ms. Johnson, please for clarification of the court's order.
Well, Your Honor, we would respectfully request, I know that as part of the condition of the plea, that if the court were inclined.
Hold on a second. Let me describe something and describe the procedure. Ms. Johnson, or Ms. Duran, excuse me. I order you to surrender yourself Friday morning at 9 o'clock to the Sheriff of Santa Fe County at the Adult Detention Center on New Mexico 14. Ms. Johnson, hold on. You have until noon Wednesday to decide whether or not Mr. Rand is going to move to withdraw her plea. Two provisions of the sentence, the fine of $14,000 and the 30 days of incarceration, go beyond the recommendation of the state. At the conclusion of this hearing, the court will prepare 3 orders. The first is an order of remand. If I do not receive from you by noon on Wednesday a motion to withdraw the plea, the court will sign the order of remand and will await the final judgment of the sentence to be circulated and presented to the court. If by noon on Wednesday you do file a motion to withdraw, the court will issue the second order, which vacates this sentence and reinstates the 65-count amended second criminal information. The court will also issue at that time an amended scheduling order, resetting this case for a preliminary hearing, essentially taking us back to where we were on October the 22nd. Ms. Johnson.
Thank you, Your Honor. With regard to the motion to withdraw, I will address that obviously with Mr. Rand, but with regard to the sentence that was imposed, Your Honor, we would respectfully request that should Mr. Rand accept and not wish to withdraw her plea, we would respectfully ask that the court allow her to self-surrender after the Christmas holiday. Your Honor, she does have 3 grandchildren she is taking care of and raising, and we'd ask that she be allowed to spend the Christmas holiday with them. And also, Your Honor, we would respectfully request that good time be authorized on those 30 days. And would the court, with regard to the GPS component, would the court allow that, because again, the fact that Mr. Rand is responsible for raising these 3 young boys, that the court allow probation to sort of a discretion by probation to confer with the court, as opposed to 2 years, that leave it essentially at the discretion of probation to come to the court before the 2-year period to terminate the GPS component of the sentence. And with regard also, Your Honor, to the fine, because Mr. Rand does have to pay restitution, would the court consider suspending the fine as well? This is quite a financial burden in terms of her means and her ability to pay this fine, since what we want obviously is to make the victims whole. We ask that the court obviously impose the probationary period, the restitution, but with regard to the fine, perhaps you would consider decreasing that fine or suspending the fine as well, Your Honor.
Let me address each of those points. As to the request that somehow probation have discretion over the GPS monitoring, that's denied. My understanding of the facts of this case is that it was pressure, anxiety, stress that caused an interest in gambling to explode into a full disorder. Those stresses won't go away as a result of where we are today. So the request to modify that or to give authority to the to the probation and parole department is denied, she will bear the expense, if there is one, for the per diem for the device itself, and also must complete successfully 2 years of probation without any violations of her conditions of probation before she can petition the court to vacate the third year. As to the request to suspend the $14,000 fine that's imposed, counts 1 through 4 are economic crimes. That punishment, and punishment is the third component of sentencing, is directed directly at the economic damage that was caused, and the court imposes the entire amount. The restitution, the order should read that the restitution should be paid first, and then the fine paid, but both have to be completed within the 5-year period of probation.
Your Honor, may the state be heard as to one minor issue?
Let me finish her questions and then I'll come back to you. The third request, which was actually the first one that she made, was a request that she surrendered herself before or after the Christmas holiday, and that she be allowed good time. Both requests are denied. Almost without exception, every adult defendant that appears before this court has a family. And the sentence will run from December the 18th at 9 a.m. and she would be released, which is this Friday, and would be released Sunday, January the 17th at 9 a.m. to report immediately to adult probation. Her probation will initiate in Santa Fe County and may be transferred to her county of residence. Ms. Moran.
Thank you, Your Honor. I just wanted to note the state's objection to allowing the defendant the opportunity to withdraw the plea. Based on State v. PRA 2009 NMSC 019, the defendant is not entitled to withdraw her plea. PRA held that the court is not required to afford the defendant the opportunity to withdraw a plea when it rejects a sentencing recommendation or a defendant's unopposed sentencing request, so long as the defendant has been informed that the sentencing recommendation or request is not binding on the court. That case was decided by the Supreme Court of New Mexico and is applicable here. The state and the defendant never bargained for a specific probationary sentence. This was left to the discretion of the court. It has always been contemplated by the court that it could impose incarceration, and that was the plea that was negotiated by the state in this case. The state is simply recommending a suspended sentence based on the specific tenets of supervised probation. There is not a specific sentencing agreement in this case or an agreement as to probation. All that we have agreed to was a non-binding recommendation on this court, and under State v. PRA, we object to giving the opportunity to the defendant to withdraw the plea as specified in the plea and disposition agreement. Page 2 and 3 specifically articulate that there could be incarceration and a fine imposed. So that is the state's position.
Let's talk about that for a second. When we were here on October the 23rd, the court rejected the original language of the plea because it was, in my view, ambiguous. The state cannot offer with one hand and then take with the other in negotiation terms and conditions. An individual citizen who is waiving their constitutional protections in exchange for a plea should have a clear idea of what the state's recommendations will be. I have exceeded that in this sentence. And as I mentioned on the 23rd, this was a drafting error. It originally began with what I described as passive language, where the state was not opposing the language used, and the practitioners that appear before this court on a regular basis know that I will not accept that kind of language because it is ambiguous and it creates expectations, and quite frankly, it's not fair. The drafting of the agreement was also not open-ended. The state did not come in the defense and say, you have a range between a conditional discharge and 8.5 years. With all of the contingencies, and particularly the 5 requested special conditions of probation, and if I haven't already said it, the court adopts all of those conditions plus the other 5 recommended by the Adult Probation and Parole Office as part of this sentence. first of those conditions is that Ms. Duran has to follow all of the terms and conditions of probation. She has to do that anyway. That's a standard condition, not a special condition. So as soon as that's imposed, it triggers the language of your plea agreement, and I believe creates the conflict that I have described. In this particular case, I tried to make clear when we were here on the 23rd that if the court did impose a jail sentence, the defense would have the opportunity, and the court would grant a motion to withdraw it, and that is exactly where we are.
Thank you, Your Honor. I understand the court's interpretation. I'm simply citing to the language within Pieri that a non-binding recommendation does not create that specific sentencing agreement in the case. It is our read of State v. Pieri that we do want that noted objection to the withdrawal of the plea based on the plain language of Pieri and also the plain language of the change disposition agreement. Thank you, Your Honor.
And I understand your position, and I respectfully disagree. Ms. Johnson?
Just to briefly point out, Your Honor, page 4 of the plea agreement states, if the court finds the provisions of this agreement unacceptable after reviewing it and any pre-sentence report, the court will allow the withdrawal of the plea and this agreement will be void. It's plain and simple. For the benefit of the bargain, the AG's office, this is part of their contract, has bargained that way. And Ms. Duran maintains that right, and we will notify the court by Wednesday whether or not Ms. Duran intends to file a motion or proceed with a request to withdraw the plea agreement.
And in response, Your Honor, if I may, since accepting the plea, there's been no aggravating factors that would otherwise change the court's perspective from when it accepted the plea. The PSR, after an exhaustive inquiry as to the facts of the defendant's conduct, came to the same juncture as the parties when the plea was crafted, namely the prorated sentence and the suspended recommendation. So I do not believe that under the language that Ms. Johnson is citing, that would qualify for withdrawal of the plea.
Well, depending on Ms. Duran's decision, we may continue this discussion. Ms. Duran, would you please rise? Ms. Duran, you've asked this court for the opportunity to rehabilitate yourself and to make amends for the transgressions and the harm that you have caused. That opportunity is standing before you. It starts Friday at 9 a.m. when you walk through the front door of the Santa Fe County Detention Center. And it ends 5 years from now when the court issues an order allowing you to be free of supervision from the Probation and Parole Office. We're in recess. The court will reconvene at 11 o'clock.
All rise.